and welcome back. You're listening to Passing the Baton. I'm Jared Hight from Tracktown Law, a virtual law firm based in Eugene, Oregon, offering flat fee estate planning and small business services across Oregon and Idaho. Today we're talking about pet trusts. That's right, estate planning for the four-legged members of your family. It might sound a little eccentric at first, but if you're someone who loves your animals like family, and you're not alone in that, then making a plan for their care isn't just sentimental. It's practical, and in some cases, it's essential. Before we get started, the usual disclaimer: I'm a licensed attorney in Oregon and Idaho, but listening to this podcast doesn't create an attorney-client relationship. Nothing here should be taken as specific legal advice. For that, you'll want to talk with someone licensed who understands your unique situation. And if you'd rather read than listen, or want to share this episode with someone who needs it, you'll find a full companion blog post at tracktownlaw.com. Every episode of Passing the Baton has a written version you can revisit, forward, or print out. So why talk about pet trusts at all? Because pets outlive their owners more often than people realize. And when that happens, the question becomes, what now? If you don't have a plan in place, your animals are legally considered property. That means they're distributed just like your furniture or your car, with no assurance of who will actually step up, or whether that person wants the responsibility. And without clear direction, some animals end up in shelters. Others are passed from relative to relative with no consistency or financial support. A pet trust changes that. Let's say you have a dog you've raised since it was a puppy. It's 6 years old, healthy, active, and expected to live another decade. You pass away unexpectedly. Your will leaves everything to your adult son, but he lives in a no-pets apartment and travels for work. What happens to the dog? Without a pet trust or a clear plan, it's an open question. Or maybe it's a horse or a parrot. Some parrots live 60 years or more. Or a special needs cat on expensive medication. In any of these cases, the financial and caregiving responsibilities don't just resolve themselves. Oregon law allows you to create a legally enforceable pet trust, either as part of your will, part of your revocable living trust, or as a standalone trust. The purpose is simple: to name a caregiver for your animal and to set aside money to pay for its care, all under legally binding terms. The trust continues for the life of the animal, and you, as the grantor, can specify exactly how the money should be used. That can include food, vet visits, grooming, boarding, medication, and even things like pet insurance or exercise services. You also name a trustee, someone different from the caregiver, ideally, who's responsible for managing the money and making sure it's used properly. This system creates a layer of oversight and accountability that you don't get with a simple, "Hey, can you take my dog if I die" conversation. Let's walk through how it might work in practice. Say you own 2 cats, indoor, pampered, high-maintenance felines. You know your friend Emily is a cat whisperer, and you'd trust her to care for them. You also know your brother is great with finances, but allergic to animals. You create a pet trust naming Emily as the caregiver, and your brother as the trustee. You set aside $10,000 to cover expenses for the cat's remaining years, and you include instructions about preferred food, vet care, and even who should take them if Emily ever can't. The trust kicks in automatically upon your death or incapacity. Emily gets the cats, your brother oversees the funds, and your instructions get followed. No confusion, no scrambling, no surprise shelter trips. Now, how much money should you set aside? That depends on the pet. Small dogs and cats may require less. A horse or exotic pet can require significantly more. You'll want to think about expected lifespan, ongoing health needs, and whether any one-time expenses might come up, like rehoming costs or renovations to accommodate the animal. Some people leave a small remainder gift to the caregiver as a thank you once the pet has passed. But here's where it gets interesting. The court has authority to reduce the trust if it finds the amount is excessive. You can't just leave your dog $5 million and expect it to stick. Oregon law requires the amount to be reasonable based on the circumstances. So if you plan to fund a pet trust, keep your expectations grounded and your math supportable. What if you don't want a full trust but still want to make some provisions for your animals? You can do that too. A simple will-based clause can nominate a caregiver and leave them a lump sum, either with strings attached or as a flat gift. The problem, of course, is enforcement. If someone takes the money and doesn't actually care for the pet or rehomes it immediately, there's not much legal recourse. That's the benefit of using a trust. It's enforceable, it survives your death, and it creates structure around something people often handle too informally. At Tracktown Law, I help clients think through these decisions as part of their overall estate plan. Some people want a full pet trust, others just want a backup plan. Either way, we walk through the animal's needs, the client's wishes, and the best legal tools for the job. For some clients, that means a detailed trust with contingencies. For others, it's a clause in the will and a separate caregiver agreement. There's no one-size-fits-all approach, but it absolutely matters to get something in writing. So who should consider a pet trust? Honestly, anyone whose animals play a central role in their life. That includes seniors with long-lived pets, people with no close family, anyone with a high-needs animal, or anyone whose estate might be complicated by disputes, distance, or delays. It also includes blended families where not everyone agrees about pet responsibilities, or where the surviving family might not prioritize animals the same way the deceased did. One more thing, pet trusts don't have to be expensive or complex. When done as part of a larger estate plan, they're often a modest addition that makes a major difference. And because Oregon law explicitly allows them, we're not dealing with gray area drafting. These trusts are recognized, enforceable, and increasingly common. If your pets are more than just background characters in your life, if they're companions, protectors, or like children who follow you room to room, it's worth putting a plan in place. A pet trust might be the most overlooked way to ensure their life continues with as little disruption as possible. To learn more, or to schedule a free consultation, visit tracktownlaw.com, and don't forget to check out the companion blog post for this episode while you're there. It's a great resource if you want to revisit the details or share the concept with someone who needs it. Next time on Passing the Baton, we'll shift gears and talk about what happens to your digital life after you die. Your accounts, your emails, your social media. Who gets access, and how do you make sure your online presence doesn't turn into a ghost town? Thanks for listening.